Welcome to a video on my channel. Today we are doing a sit down, as you guys can see, and as you guys can already tell by the title of the video. So today we are going to be talking about customary marriages, and I just wanted to say and explain why I wanted to talk about this topic. It is something that people have been asking me about. 2 or 3 people have asked me about their situations, so I figured there is clearly a demand for this topic. There is clearly not enough information where people don't understand what they get themselves into and what are the consequences of the things that they get themselves into. So let's just get into it. The topic for today is customary marriages. Customary marriages has a lot of little subtitles, but I'm just gonna focus on the requirements, the consequences, and the dissolution, because we can get into maintenance, we can get into property, we can get into interstate succession when the person, either of the spouses, die. We can literally get into so many things, but today I just wanted to give a basic overall view and a basic understanding, just so that people understand the things that they're getting themselves into. Because one thing that you guys need to realize is that ignorance of the law is never a good defense. You not knowing something is not a good enough defense in court. So I'm going to start off with the definition, and I'm not going to make up my own definition of what customary law is. I have taken this definition from the act of what a customary marriage is. So according to the act, a marriage in terms of customary law requires the use of customs and traditions usually observed among the indigenous African people of South Africa, which forms part of culture of these people. Customary marriages also include Islamic marriages and Hinduism. So I'm going to get into 2 segments. There are 2 different types of customary marriages. So there are those marriages that were entered into before the promulgation of the act, which the act was enacted in 15 November 2000. I'm just going to give a young summary of the marriages that were entered into before the promulgation of the act, and then I'm going to go in a little bit deeply for marriages that were entered into after 2000, because I feel like most of the people our age group are married after 2000. And most of the marriages that are entered into now are marriages that are governed by the act. So we need to know more about what the act says than what the act didn't say, or what happened without the act, because now we actually have legislation to help us. So before that, all customary marriages were recognized, including polygamous marriages, and every wife was given the title of a spouse. Okay, so if you were a polygamist and you had many spouses, those people were recognized as your spouses, and thus they had the same patrimonial rights and the joint estate. Okay, all those marriages will be governed by the customary law, whether monogamous or polygamous. So when the act came about, people were given a 10-year period, a 10-year window period, where everyone whose marriage was entered into customary union, they have to have their marriage registered in terms of the new act. But that one also came with a lot of consequences and a lot of things not being answered, because now you're saying their marriages are in terms of the new act. The new act does not recognize so many spouses unless the court has given consent. What happens to the joint estate? So there's a lot of questions around that. I am not going to enter into that. I am going to enter into marriages entered after 15 November 2000. The act has requirements for a valid customary union. Okay? First and foremost, the parties need to be above the age of 18. They need to give consent that they want to get married. But if the people getting married, or one of the spouses or one of the parties getting married is under the age, under the legal age, then the consent has to be acquired from the parents. I think one of the reasons why this is one of the requirements is because previously, like in some cultures, there was this act called Ugutwala, which is like an abduction, where they just take you and they marry you, and without consent, without you having a say, without your parents even knowing. So now they are saying that if the parents don't agree and you are underage, then that marriage is basically null and void. The other requirement is that the marriage must be negotiated, it must be entered into, and it must be celebrated in terms of your customs. One thing that people get wrong is that they think that lobola, if there's no lobola paid or if the lobola is not finished, then this marriage is not valid. Unfortunately, the Act does not make any specific reference to lobola. I even noted that down, that payment of lobola is not specific in the Act. Sometimes people finish lobola, sometimes people don't finish lobola. Sometimes there isn't any lobola, it's just negotiations and then there's a party. The Act does not say if there is no lobola, there is no marriage. If there is lobola, there is a marriage. It does not specify. But there needs to be negotiations, it has to be entered into, and there needs to be celebration in terms of the people involved customs. Okay? And then if you want to enter into a polygamous marriage right now, you can do so. You are allowed to do so. But you need to make an application to the High Court to say, High Court, I want to enter into a future matrimonial property system by this. So if you want to get into a polygamous marriage, you are allowed to do so. But you are only allowed to do so if you have consent from your first wife. If you also have to enter a application to court to say that you want to enter into future matrimonial property systems with other people, and the court must grant it. But if you also fail to enter into this application or do this application at the High Court, it doesn't mean that the marriage that you have entered into after your first wife becomes, with your second wife becomes invalid. That second marriage is still valid, but it will be governed by out of community of property. So it means that the second wife does not enjoy the matrimonial property rights as the first wife. But if you do, and then you get a second wife, then they're all your wives, then they all get to enjoy the benefits of the joint estate. Okay? Yeah. Once you've entered into customary marriage, once you've celebrated and all that, it is the responsibility of both parties, of both spouses, to go to Home Affairs 2 to 3 months after the max is 3 months. 2 to 3 months after the wedding or the celebrations for you guys to register. Once you guys have registered, and once the registering office at the Home Affairs is satisfied that yes, this is a marriage according to customary law, then you get what we call a registration certificate. And what the registration certificate does is basically like a marriage certificate, okay? But it's just to help you avoid a lot of technicalities in the future, you know what I mean? Just to have your things in order, just to know that my things are in order. I know I'm married in customary law, but our marriage is registered and we have a registration certificate. So that's basically the purpose of it. And a question is, does the non-registration of a customary marriage make it invalid? Unfortunately, no, it doesn't make it invalid, because it did happen. It's just that you guys didn't register it, and it's just that you guys didn't take the further steps to actually solidify, or like you guys didn't solidify it after the marriage, but you guys are basically married. Okay, the consequences of, or the effects of getting into a customary marriage is that a customary marriage automatically by law becomes a marriage in community of property, meaning that both spouses have their estates becomes a joint estate, and they share assets and liabilities. So you come with your assets and your liabilities, he comes with his assets and his liabilities, and you guys become one happy family. Okay? But if you don't want that, and you are the girl who has her coins in check, or if you feel like your husband is maybe like a high risk type of business type of person, it would be advisable for you guys to enter into an anti-nuptial contract to say, okay, what I come into is mine, what you come into is yours. Maybe we will share the fruits of what happened in the marriage, or even the fruits of what happened in the marriage, we still separate. And that makes your marriage to be out of community of property. And if you do enter into a customary marriage and you have not gotten into an anti-nuptial contract before the marriage, you can still enter into a post-nuptial agreement where you guys agree that, okay, I'm going to have mine, you're going to have yours, and this is how we're going to divide everything. But remember that the court has the discretion to grant a post-nuptial or not. Unlike an anti-nuptial, there is no judge, there is no application. It's you, it's your lawyer, it's your notary doing the anti-nuptial contract. And it's basically like, you know, when they say pre-nuptial and post-nuptial, yeah, that's basically it. Before the wedding, then you avoid a lot of people, you avoid a lot of up and down. All you need is the notary and application, and it's done. But if it's post-nuptial and you guys are already married in community of property, the judge has the discretion to ask so many things are taken into consideration, and so many things can affect the decision of the judge to say, is he granting you or is he not granting you? Because sometimes it might be to the detriment of one of the parties to enter into this post-nuptial. It needs to be above board, and your reasons need to be really like proper reasons, so that you guys can enter into that post-nuptial. So that's basically it. So the conclusion is that spouses married, for me, the conclusion that I'm going to give you that I've written down here is that spouses in customary marriages need to be cautioned that just like a civil marriage, it needs to be dissolved at court. Okay, you're gonna have to get a decree of divorce if you're married in customary law, and that is what people don't and fail to understand, because you get people. These are the situations that I was telling you, where people were married in terms of customary law, and there was never like a wedding, and then they just decide to live separately. That does not mean that you are free and well to marry anybody. No, it basically means that you are still married to someone out there, and whoever you marry now, if you didn't have that application at the High Court, that marriage is going to be invalid, and that person is not going to enjoy any matrimonial property rights. So you can't just get a separation. Like, I remember someone was asking me about, can we do a separation agreement? I'm like, you guys are married in customary law, and I don't know if South Africa actually recognizes a separation agreement. You guys just need to get a divorce. And one of the people who had asked me is that I'm scared that this person and I have not been in a relationship, this person has not been maintaining the child, is going to benefit from, and he doesn't have much of his own things, he's going to benefit unfairly from my riches. And I told her that once you enter your summons for a divorce, you can also do an application for a forfeiture of the benefits of the joint estate. That is basically an application where you give reasons to the court to say, Your Worship, my Lord, this person honestly cannot benefit from my estate because of these reasons. He has not been supporting the child, he doesn't do this, he doesn't do that, and for those are the reasons why this relationship couldn't work out, and those are the reasons why I don't want him to benefit. And once again, it is upon the discretion of the court to decide whether they take your reasons, whether your reasons are valid enough. It is in the court's discretion, and that is why we have judges, so that where the law is lacking, they can come in with their discretion, their understanding, experience, and give us an outcome. And always remember that if you get married in community of property and you do not have an anti-nuptial contract, you are married in community of property, but that does not bound you. If you want to get into a post-nuptial contract agreement with your spouse, you guys can do that. You can do that at a notary. People who do anti-nuptial contracts and post-nuptial contracts are notaries. Okay, so they are attorneys, but they have written the exam of a notary, and they have specific rights and abilities to do that. I myself, I cannot do that. I have not written the notary exam, and that's why I'm just giving you that light. And remember that even if lobola is not paid, the act does not specify on that. And I hope that this video is going to help you in the future. If you're not married, it's going to help your family. It's going to help your friends who are about to get married, or anybody that you might know who might be in the dark with the things like that. I hope you guys enjoyed the video. I really enjoyed taking this video and sharing with you guys. I keep looking at my watch because I have a 10 o'clock appointment. It is 10:15. I will see you guys next time on a vlog, most probably, because as I did mention in one of my other vlogs that I'm currently home right now. And peace, guys. Don't forget to comment, don't forget to like, don't forget to subscribe, and don't forget to click on the notification bell so that you're notified every time I upload any content. And for anybody who's new here, welcome to the Lawyer Corner, where we give you information and knowledge. Alright guys, thank you so much for watching. Leave your comments down below if you have any questions that you want to. Leave your questions below, and hopefully, or maybe, the next video will be me answering the questions in the comment section. Alright guys, let me leave it there. Bye. Peace out. Love you. I said love you.